Hey guys, it's me, Professor D, and welcome back to my channel. On this video, I'm going to be covering legal issues. So if you had any questions about legal issues as it pertains to nursing, malpractice versus negligence, slander versus libel, you are in the right place. So guys, in order to support this channel, please do not forget, like and subscribe below. Any nursing friends or any friends you have who are in the nursing program, recent graduates, please feel free to forward this video to them. Any videos that you'd like to see me make in the future, just go ahead and leave it on the comment section below and I'll make sure I make a video for you. So let's get into it. First question. What standard of care applies to the nurse student's conduct when providing care normally performed by a registered nurse, RN? 1, the same standard of care as an RN. 2, a standard of care of an unlicensed person. 3, no special standard of care because her faculty member is responsible for her conduct. Or 4, a standard similar to but not the same as a staff nurse with whom she's assigned to work with. And guys, if you need a moment to think of your answer, just go ahead and press the pause button and you can play when you're ready. So guys, the correct answer is 1. As a nursing student, once you hit that floor, let me make this clear. That is a myth. You know, when you're a nursing student and the nurse says, oh, you better be careful, you're working under my license. No, you're not working under their license. If you do something wrong, you are the one who's going to need a lawyer because you are the one who's going to court. Okay? You're not working under that nurse's license. Those same expectations that they have for that RN, they have for you because you took it on the minute you stepped on that floor as a nursing student. And you took on the responsibility of a patient. So just know you are responsible and you are held to that same level of responsibility as the RN. Okay? Next question. A physician asks a family nurse practitioner to prescribe a medication that the nurse practitioner knows is incompatible with the current medication regimen. If the nurse practitioner follows the physician's desire, which of the following is the most correct answer? 1, the Good Samaritan law will protect the nurse. 2, the nurse practitioner will be liable for the action. 3, this type of situation is why nurse practitioners should have malpractice insurance. I'm sorry, guys. 4, if the nurse practitioner has developed a good relationship with the client, there will probably not be a problem. And the correct answer is 2, the nurse practitioner will be liable for the action. It doesn't matter what the doctor asked you to do, because let me tell you something. I have never seen a group of professionals that will cover themselves quicker than the physicians will. Play with it. Okay? So even if the doctor tells the nurse practitioner to do something, at the end of the day, the person who wrote that order, who did what was wrong, they are the one who is going to get in trouble. So it's going to be the nurse practitioner. The nurse practitioner can't go to court or go to the deposition and say, oh, well, the doctor told me to do it. Well, excuse me, did you get your NP license at Disney World? No, you went to school. You got an education, right? So you know the standard of care that you're going to be held against. So doing something that you know is wrong, doing something that anybody with your level of education knows better not to do, and you did it, that's malpractice. Okay, and you'll be held accountable for it. Let's look at our other choices. 1, the Good Sam laws will protect the nurse. Absolutely not. The Good Samaritan law was established to protect the nurse during an emergency situation where the patient cannot give consent because, let's say it's a car accident. Their heart stopped. Obviously, they can't open their eyes and say, please give me CPR. It's an emergency situation. And you give that patient CPR, they can't come and sue you later as long, here's the key, as long as that licensed professional did for the patient what any other licensed professional would have done under that given circumstance. So what do I mean by that? You drive by the scene. You see an accident. You're a licensed professional. That person's not breathing, and you start giving them CPR. Can they sue you down the road because while you were giving them CPR, a rib or two broke? No, because during normal CPR, if you're doing it the right way, depending on that patient's age and how frail they are, you might break a rib or two. That happens, okay? They can't sue you for that. But let's say you decided to give them CPR, and instead of pumping down with your palms and your wrists, let's say you did it with your foot. You stood over their chest and you just started pounding down on their chest to do CPR. And then you break a couple ribs. Can they sue you? Absolutely. Why? Because any other nurse that was trained, that was educated, that passed the NCLEX knows better. Is not going to do it. So that's where the key lies, okay? So yes, the Good Samaritan Act, that it protects you during emergency situations, but only when you provide a standard of care that anybody else with your license would have done, okay? So moving on. Choice 3, choice 3 is crazy. I'm not even going to discuss choice 3. That's absolutely crazy, talking about that's why we have malpractice insurance. That doesn't protect the patient, so absolutely not. And then choice 4, if the nurse practitioner developed a good relationship, they probably won't get sued, or it's probably won't a problem. Yes, it will be a problem. Those happy, nice, good feelings go right out the door, and you will find yourself sitting in a deposition for a lawsuit that's coming around the corner, okay? So number 2 is the correct answer. The nurse practitioner will be liable for the action. Next question. A registered nurse interprets a scribbled medication order by the attending physician as 25 milligrams. The nurse administers 25 milligrams of the medication to the client and then discovers that the dose was incorrectly interpreted and should have been 15 milligrams. Who would ultimately be responsible for the error? 1, the attending physician. 2, the assisting resident. 3, the pharmacist. 4, the nurse. The correct answer is the nurse. The nurse is the one that misinterpreted that medication. If there was any question, even the hint of a question, what should that nurse have done? Gone back to the doctor and clarified. Okay, so let me make this clear. When there's a question about a medication order, the prescription, you go to the doctor. When there's a question about the actual medication, interaction, adverse effects, side effects, you go to the pharmacist. You see the difference? If you have a question about the order, about the prescription, you ask the doctor. If you have a question about the actual medication, you ask the pharmacist, okay? There are issues concerning death and dying. Let me go back. There are issues concerning death and dying may influence nursing practice, which the nurse recognizes. Concerning the legalities of death and dying issues, which of the following are true? 1, passive euthanasia is illegal in all states. 2, assisted suicide is a constitutional right. 3, organ donation must be attempted if it will save the recipient's life. 4, feedings may be refused by a competent individual who is unable to self-feed. And the only correct answer in all of these choices is 4. Everything else is wrong. 1, 2, and 3 is absolutely incorrect. Okay? 4 is true. You want to know what makes it true? That one word, competent. That means that that patient is cognitively intact, right? But not only are they cognitively intact, legally, they're allowed to make that kind of decision. So who would be considered competent? Obviously, somebody who, like I said, they're cognizant of the decisions that they're making, okay? They're not somebody who's been deemed by the state or by the government to be insane. Because if you're insane, if you're legally insane, can you make decisions for yourself? No, you're not competent. Who else? in order to be competent, you cannot be someone that's under duress. So that means you can't have someone that's forcing you to make those decisions, right? In order to be competent in making a decision, you cannot be under the influence. So you can't make a decision while you're drunk. You're not going to be competent, okay? So that keyword in number 4, competent, that's what made the answer right, okay? Feedings may be refused by competent individuals who are unable to self-feed. Who else is competent? I want to give you another example. Well, I'll tell you who would not be competent. Someone who is underage. If they're underage, they can't make decisions for themselves except in certain circumstances, certain situations, such as someone who's underage, but they're married. Someone who's underage, but they're in the armed forces. Someone who's underage, but they've been deemed legally, what's the word I'm looking for? They're emancipated, okay? They're not legally they're not legally responsibility of their parents anymore. So there's certain circumstances anyone underage can be competent, and those are just a few. But for the most part, if they're underage, they're not considered to be competent to make decisions for themselves. Next question. Which one of the following actions is an example of an unintentional tort? 1, restraining a client who refuses care. 2, taking photos of a client's surgical wounds. 3, leaving side rails down and the client falls and is injured. 4, talking about a client's history of sexual transmitted diseases. And the answer is 3. All the other choices, no, you did that on purpose. Talking about them, talk about their STDs, taking pictures of their wounds, restraining them, right? Those were intentional, right? But look at 3. You left the side rail down, and then what happened? That patient tried to get up, they fell, and they injured themselves. So an intentional tort is when you do something unintentionally that causes harm to the client, such as in number 3. Next question. Which one of the following individuals may legally give informed consent? 1, a 16-year-old for her newborn child. 2, a sedated 42-year-old pre-op client. 3, the friend of an 84-year-old married client. 4, a 56-year-old who does not understand the proposed treatment plan. And I'll give you a moment to think of your answer. And the correct answer is 1. Why? The key word in 1 said a 16-year-old. And I know what you're thinking. Well, Professor D, she's 16. But what does it say? For her newborn. So here's what's so crazy. She's underage. She can't give consent for herself because she's underage, but she is allowed to give consent for her child. So a female that's underage or a male that's underage, they cannot give consent for themselves. The parents have to give consent for them, but they are allowed to give consent for their offspring, for their child. So let's look at our other choices so you can know why those are wrong. 2, what? A sedated. That means they're under the influence of some kind of medication that alters their cognition. So they can't give consent because I just told you a few minutes ago, anyone that is under any type of medication, they cannot give consent, okay? So a patient that's sedated, they can't give consent. 3, the friend of a married adult. And look how they tried to trick you because you see that word married and you're like, okay, they can give consent. But no, because look what it said. It's the friend of the married person, not the married person. Because yes, I told you if they're married, even if they're underage, if they're married, they can give consent for themselves. However, this is not the married person we're talking about. We're talking about the friend of the married person. You see how they try to trick you? Make sure you read closely. Number 4, The 56-year-old who does not understand. What does that mean? Cognitively speaking, do they know what's going on? No, they don't. Can they give consent? No, they can't. So out of these choices, the only one who can give consent is that 16-year-old. And why? Because they're not giving consent for themselves. They're giving consent for their child. Next question. When a nurse signs as a witness on an informed consent form, she is indicating that the client, 1, fully understands the procedure, 2, agrees with the procedure to be done, 3, has voluntarily signed the consent form, 4, has authorized the physician to continue with the treatment. And I noticed that you students tend to get this type of question wrong all the time. I don't know why, but let me clarify this for you so you don't ever make this mistake again. The correct answer is 3. As the RN, your job is simply to witness that the client is the one that signed the consent, and they did not sign it under any duress. They did not sign it under any mind-altering drugs. Okay, they were not under the influence. That is your only job. You see, 1, and this is what you guys tend to mix this up with. You see, 1 fully understands the procedure. You want to know whose job that is? The surgeon's. That is not your job, not 1 iota, to make sure that that client fully understands the procedure. What do I mean by that? If that client has any questions about what may possibly happen during the procedure, surgeon. If that client has any questions about what may possibly happen to him or her if they don't have the procedure, surgeon. If that client has any questions about what may happen during the procedure, surgeon. All of that, the surgeon's responsible for. Your job is to witness the consent, make sure it's the client signing the consent, make sure that that client is not under any influence, and put that consent in the chart. That's it. Now, let me tell you how they're going to try to trick you. They're going to tell you that the surgeon came in, the surgeon explained the procedure, the client agreed, the client signed, the surgeon was paged because it was an emergency. They had to go save somebody's life. 2 minutes of that surgeon walking out the door, the client says, you know what, I really didn't understand this part of the procedure. Can you explain it to me? What do you do? Now, the way that that question's written, it's written in the way to scare you. Well, oh my gosh, the surgeon is about to go save somebody's life. Guess what? We don't care. Who do we care about? Our client. You're going to call the surgeon to come back in. Yeah. You're not going to try to explain that procedure or those details to the client. You do not do that. You page that surgeon, you call them back in, you say the client has more questions. Okay? A client is told by the nurse that he has to take the medications, including an injection. The client refuses the medications, but continues to have them administered by the nurse. This action is an example of the intentional tort of A, assault, B, battery, C, malpractice, or D, invasion of privacy. And the correct answer is B, battery. So as students, this is another one. I don't know why you guys get these confused, but I see this a lot. Let me explain the difference between assault and battery, because a lot of people use them together interchangeably and they're really not, okay? So assault is the threat of bodily harm or even touching a patient against their will. Just the threat of you doing that, that's assault. Battery is following through with that threat. So in this question, it says that the nurse says you have to take this medication, including a medication. The client refused, but the nurse continues to give it anyway. So you're giving that medication, the injection, against their will. You now went into battery. So when the patient said, I don't want it, and you say I'm going to give it to you anyway, that's assault. The minute you do it, that's battery. Okay? Malpractice. This is another thing. You guys tend to confuse malpractice and negligence. So let me clear this up for you. Malpractice is doing something that you should not have done. Malpractice is doing something that anyone else that was trained with your license would never have done, and you did it. That's malpracticing. That's malpractice. Okay? What is negligence? Negligence is not doing what you should have done. Negligence is not doing what anyone else who's been trained in your field that has your license knows to do, and you didn't do it. So an example of that, patient just came from surgery. They're still groggy. You don't put that bed in the lowest position. You don't put that side rail up. So you turn around and that patient just falls out that bed. You were negligent. You were negligent to put that bed in the lowest position. Or you're about to ambulate a patient, and what do? You sedate them right before ambulating them. Actually, that is an example of actual malpractice because you're doing something you shouldn't have done. Wrong example. So anyway, that's an example of malpractice. So the point is, malpractice is doing something that you should not have done, and negligence is not doing something that you should have done. So a perfect example, I'll give you another example of negligence. Negligence is patient comes back from surgery and you don't bother to take their blood pressure. You don't bother to look at the dressing. Not even remove the dressing, but just look. And you guys all know, because from my, what was that video? That video I did on the tips for passing NCLEX, one of the things I told you, any patient that comes from surgery, what are our top concerns? Them hemorrhaging, them developing a blood clot in a DVT, and what was our third concern? What was our third concern? They just came from surgery, bleeding, DVT, infection. Okay, those are our top 3 concerns anytime a patient comes from surgery. So you have a patient just came from surgery and you didn't even check their blood pressure to see if the blood pressure is going down. You didn't check the heart rate to see if the heart rate was going up, which would most likely tell you what, that patient's probably bleeding out somewhere. You never bothered to look at the labs, to look at the H&H, to see if it's going down and let you know they're probably bleeding out somewhere. You did not bother to eyeball the dressing to see if that dressing got fully saturated within 30 minutes to let you know that patient was bleeding out. That's negligence. That patient ends up bleeding out, having a hypotensive crisis. You caused that through your negligence, okay? So anyway, that's the difference between negligence and malpractice. Which of the following statements made by the nursing student regarding responsibility for provided care requires immediate follow-up by the nursing instructor? 1, I'm not held to the same standards as the licensed RN. 2, I am required to provide the safest, appropriate care I am capable of. 3, my clinical instructor is ultimately responsible for the care I provide. 4, no one expects nursing students to provide care on the level as an experienced RN. Okay, guys. So I took a little time because I really don't like this question the more I think of it. I'll tell you what the answer is, but I'm going to explain to you why I don't like this question. So the correct answer is 3, my clinical instructor is ultimately responsible for the care I provide. That's absolutely wrong. And you know it's wrong because I told you this already. Who is ultimately responsible for the care that you provide? You. You are. The minute you hit that floor and you take that responsibility to care for a nurse as an RN student, you are held to the same standards as the RN. And the reason I don't like this question, if you look at 4, it says no one expects nursing students to provide care on the level. Oh, okay, never mind. I like this question. I read this too fast. So 4 says no one expects nursing students to provide care on the level as an experienced RN. Excuse me. And that's absolutely correct. We know you're a nursing student. You're going to make mistakes. You're going to make little mistakes. We don't expect for you to work in the same capacity as an experienced RN. So that's absolutely correct. 2's absolutely correct. You better try to give the best, safest care that you can. And 1's correct. I am not held to the same standard as a license. Oh, this is horrible. Guys, forget everything I said. Number 21's horrible. I don't know what they're talking about. Forget it. Let's just throw number 21 out because this is absolutely crazy. Because absolutely, as a nursing student, they are held to the same standards. Absolutely. So for number 21, just to recap, because I didn't mean to confuse you. Number 1, I am not held to the same standards as a licensed RN. As a nursing student, yes, you are. As far as care, as far as medication administration, as far as wound care, you name it. Yes, you are. Look at me in my eyeball when I tell you this. As a student, yes, you are. 2, I'm required to provide the safest, appropriate care that I'm capable of. That is absolutely true. 4, no one expects nursing students to provide care on the level of an experienced RN. That's absolutely true. What's false here is 3. My clinical instructor is ultimately responsible for the care I provide. No, you are responsible for the care that you provide. All right, moving on. Next question. The nurse is having difficulty reading the prescribed dosage on a handwritten order for a pain medication. The most appropriate action to ensure the client's safety and to minimize legal issues is for the nurse to 1, ask another RN to confirm the order. 2, request a pharmacist to interpret the order. 3, call the healthcare provider to clarify the order. 4, consult a current drug book to determine the normal dosage range. And I know you all know this answer because I gave it to you just a few minutes ago. The correct answer is 3. You're going to call the provider, the person who wrote the order, to clarify. So let's talk about this. There are a couple other things that you guys need to know about calling the physician to clarify. You have a question about the order, you call. When you're calling to clarify an order, or you're getting a telephone order, so it's a new order, not just a confirmation. If it's over the phone, you better have another nurse listening. And what you do, you repeat that order back to the physician, and you have the physician say, yes, this is what I want, because God forbid that you go ahead and give this medication, and it was a different medication that the physician wanted. You know what that physician's going to say? I never said that. And all you have is, oh, well, I called them and you can't prove it. Okay? So you're going to do it over the phone with another nurse listening, and you are going to repeat that. Don't just have them tell you the order. Say, yeah, that's right. No, you repeat it back to them, and you have another nurse that is a witness that, yes, they witnessed that, yes, that's what the physician wants. Okay? A couple of other things I got to talk to you about. So let's look at other choices. 1, ask another. You better not ever in your life ask another RN to confirm something that somebody else wrote. Go to the source. So we're getting rid of that. 2, request the pharmacist to interpret the order. Look how they try to trick you. Request the pharmacist. What did I tell you about the pharmacist? When do we go to the pharmacist? When we have a question about a medication, not the order. We have a question about a medication itself. Whenever you have a question about a medication, you only have 2 choices. You consult the pharmacist, or you consult an updated drug book. That's it. You never go to the physician about a medication, about the drug, And you never go to the pharmacist with a question about the order. If you question the order, you go to the doctor. If you question the drug, you go to the pharmacist or an updated drug book. That's it. Those are your only choices. Oh, I hit my 30-minute mark and I have so much more to cover. Okay, guys, last question. I'll try to make another video if you guys really want it. If not, we're going to keep it moving. So last question. Which of the following statements made by the nurse puts the nurse at risk for assault of the client? 1, you'll be sorry if you don't agree to take this medication. 2, you can't refuse the medication if you really want to feel better. 3, I'll be so disappointed in you if you don't take your medication. 4, I'll tell your son you aren't cooperating if you don't take your medication. And the correct answer is 1. Remember, assault is the threat of bodily harm or the threat of even touching the patient against their will. Okay, guys, I'm going to stretch it just a little bit longer. Okay, next question. The nurse is heard stating to another staff member that the client in room 54 is such a whiner. You would think she was dying. The nurse is liable of 1, libel, 2, slander, 3, malpractice, or 4, invasion of privacy. The correct answer is 2, slander. So let me explain the difference between slander and libel. Okay, so both are defamation of character. You're talking bad about the person, you're defaming their character. The only difference, libel is when you defame the character in writing. Slander is when you defame someone's character verbally speaking. That's the only difference, okay? So in this situation, obviously they were talking about the patient, so the answer is slander. Malpractice, I explained to you what malpractice is. Doing something you should not have done that anybody that was trained in your same field with your license would never do. And invasion of privacy, that is intrusion into that patient's private matters. So just because they're under your care doesn't mean you have the right to be all in their no-no zone, right? All in their business. No. So let's say a patient, you walk into the patient's room and they're finishing up a conversation with their wife and they were arguing. It's not your right to go in there and say, oh, what were you guys arguing about? I bet she was cheating on you because she looks like a little, I don't know what they call them these days, but whatever. Okay, so you don't have that right. So invasion of privacy is any intrusion into a patient's private personal matters. It has nothing to do with their health. Okay. All right. Last question. Which of the following nursing statements reflects the best understanding of the importance of appropriate nursing documentation regarding risk management? 1, if the client isn't compliant, I'm sure to put that in my notes. 2, I'm always careful to document any changes in the client's condition. 3, my notes are proof that I provided the client with effective, appropriate care. 4, when there's a lawsuit, the nursing notes are the first thing the attorney looks at. And guys, the correct answer is 3. That's the correct answer. Remember, if it's not documented, it didn't happen. And that's just how it is in the medical world. If it's not documented, it didn't happen. So if you want to prove that you gave quality care, it's got to be in your documentation. Guys, I hope you enjoyed this video. Please support this channel to keep more coming by doing what? Liking, and most importantly, subscribing below. Please send these videos to any friends you have that are in the nursing programs or new grads ready to take their boards. Thank you for joining me, and I'll see you next time.